Yes, good morning and welcome to the program. Know Your Right on Lagoon Radio. It's our legal program. Yes, where we educate you on your fundamental rights as a citizen of Nigeria. I am Anosike Chimezie, and it's a beautiful Friday morning, 16th of July 2021. And it's 19 minutes gone past the hour of 9. We apologize for coming a bit late on the program. Download the app on Google Play Store and Apple Store. Follow us on our social media platforms on Facebook, Lagoon Radio Nigeria. Of course, we are live on Facebook. And on Instagram, Lagoon Radio NG. You can listen to us directly via the link, www.lagoonradio.ng. And today, we are talking about the value of trademark protection for brands. Yes, the value of trademark protection for brands. And our guest this morning is Barrister Olumakaiye Mayowa. Barrister, good morning and welcome to the program.
Good morning. Thank you for having me.
Yeah, hope I got that name very right.
Yes, you did.
Okay, yes. Now, let's get into it. When we talk about trademark, give us a sense of what trademark is all about.
Okay. I will start by giving a very simple and straightforward definition that everybody can relate to and understand. So, a trademark is basically a mark. It could be a mark, it could be a word, it could be a combination of a mark or a word that identifies what a brand is or identify what a product or even a service stands for. So we have almost every notable brands have a trademark that you can easily identify them by. You know, when you see Coca-Cola, you know, okay, this is the brand. When you see the ShopRite logo or trademark, Domino's logo, you can easily just tell what the logo is, what the brand that the logo identifies. Then officially the trademark Act of Nigeria defines the trademark as a word, that shows the relationship between the product and the source the product is coming from. So basically that's what a trademark is in simple terms.
Okay, when we talk about this brand and particular, so what is the scope of the coverage for trademark?
Sorry, please can you take that again?
What is the scope of coverage for a trademark?
Okay. So a trademark can be used for both goods and services.
Okay.
So depending on whether you are a product deliverer, if you sell goods or products, so you can have a logo or a word or a trademark over that. As a service provider as well, you can also have a logo, that anybody that just sees the logos know that, okay, this person, for example, like the CNN logo, once you see it, it's a service provider. So you know that, okay, this trademark protects this. So the scope is basically for goods and as well as services.
Okay, now talking about goods and services, and these days in Nigeria, in the entertainment industry, you see a lot of comedians online and the rest of them. Those set of people, do they also need a trademark?
Yes, of course. Some of them, a trademark, as I said, could be a word or a logo or a mark. Some of them, their names, they can trademark their names. So, yes, comedians, musicians, artists, anybody in general can decide to trademark a word. For example, one of the most recent controversy that came out over a trademarked name was on Big Brother Nigeria. Katrina, she trademarked the word boss lady because she was like, everybody knows her as the boss lady. So, yes, words or names can be trademarked.
Okay. Now, what is the position of the law on trademark? What does the law say about trademark?
Okay, so I'd initially given what the definition is. And so the Trademark Act provides that for a person to, have rights over a trademark, it can be either through registration. Officially, if you register the trademark with the trademark registry, yes, of course, that means you have a right to make use of the mark and to stop any other person from infringing on your mark. Then aside from registration, if you can prove prior use, say for example, you've not registered the mark, but you can prove that you've been using it for a very long time, anybody can easily associate the mark to your brand. Anybody knows that, okay, this mark belongs to this person. You can also have a form of protection. Although the difference between registration and usage is the fact that under registration you can sue for infringement. But where you've not registered your brand, but you only have, right as of use, you can't sue for infringement. At best, you can just maybe bring an action for passing off. That's the best you can do. So that's the difference. Then, aside from registration and use, you can also get a right over trademark if you're assigned or licensed the trademark. So basically, those are the areas in which you can get a trademark under the law.
Okay, now you talked about this registration and the rest of them. What are the steps if I must register? What are the steps to follow to register the trademark?
Okay, first of all, I would say get a lawyer. It makes it easier. And then I'll just proceed to just outline what the procedures are. So first of all, you have to conduct a search with the trademark registry to be sure that the mark is not in use, to be sure that it doesn't, go against any of prohibited marks under the law, to be sure that it's not similar to any mark that's currently in existence, so it doesn't become an infringement on someone else's right. So after the search, if you get a confirmation that the mark is registrable, then you proceed to send a formal application to the registrar. And if you have an agent working on your behalf, you have to execute a power of attorney or some form of authorizing the agent to do the application on your behalf. Afterwards, after the registrar gets your application, they go through it to see if it complies with all the necessary criteria. Then they send an acknowledgement letter just to acknowledge your application. And afterwards, if you're good to go, they send you a formal acceptance letter, after which your application will be published in the trademark journal. So usually within a period of 2 months, to allow anybody that wants to make any complaints to say this mark is similar to mine or whatever. So you have a period of 2 months after publication to come forward to the registrar and just lay your complaint. So if within that period of time nobody comes around to file any notice of opposition to the registration of that mark, then you'll be issued a certificate of registration, which is valid for first 7 years, and it can be renewable afterward for 14 years. But so if during that period of publication someone files a notice of opposition saying that this mark is maybe deceptive, it's similar to mine, or brings up any other reason why the mark should not be registered, then they have to file necessary applications before the registrar, and the registrar would give a ruling. And if either of the parties is not satisfied, they can move on to the Federal High Court to appeal the matter.
Okay, now you've talked about this trademark, and we've heard about copyright and also franchise. Can you just give us the differences? What is the difference between trademark and copyright?
Okay, thank you very much. So a trademark, as I've said before, is just a word or a mark that just shows the brand and identifies the brand in relation to its source. A copyright, on the other hand, although it's also a form of intellectual property, they're all basic forms of intellectual property. But a copyright is an intellectual property right that deals with literary works, protects literary works, protects artistic works. So let me break it down in the simpler form. So for example, let's say we have I'm trying to look for a common literary work. Okay, let's say Americana by Chimamanda, right? Okay. So the book itself is protected by the work, the literary work is protected by copyright. Then the logos are protected by trademark if they are being registered. I don't know if that distinction is very clear, but yes, so that's the distinction. Then with franchise is not necessarily an intellectual property right. It's just an authorization to make use of a brand, maybe a brand name or a brand logo or whatever. So it can cover authority to use a trademark. Say for example, we have a lot of franchises around, like ShopRite for example is one very popular, or most of the locations we have in Nigeria, they're franchise of the main, just like several other restaurants and all that we have in Nigeria, they have their major headquarters and outside the country. So yeah, that's the difference.
Okay, just like trademark and franchise, do we also have steps to follow?
It's a contract. A franchise
Okay.
is just basically a contract. So I have a brand and you want to make use of it. I just sign a contract with you to just, okay, yes, you have the right to use my brand on so and so steps. Is follow this, follow this. So a franchise is basically a contract as opposed to a trademark.
Okay, and now, is this rights, are they absolute?
Yes, to some extent. Although we have exceptions to trademark rights. So, say for example, some of the exemptions I'll mention are so where okay, let me start with this. So, a trademark is usually registered on the ground that you are going to make use of it, or you're already making use of the mark. So if someone is able to prove that this mark, when you register, you had the intention of using it, or for the past 5 years, according to the Trademark Act, you're able to prove for the past 5 years that of registration of a mark, the proprietor, that's the owner of the mark, has not made use of it. You can file an opposition and ask for the mark to be cancelled. So that person's rights can be terminated over the mark, and anybody else can, step in to use it. Then aside that, there are other exceptions. So if you're using, there's a concept called the first fair use principle. So say for example, you use a work on maybe for commentary, for news reporting, you use people's, literal works, or you use their logo, things like that, it will not amount to an infringement of the logo. If you use it for, say, satire or parody, those things will not amount to an infringement of the rights. Okay, I think basically those are the two major exceptions to, ownership of trademark.
Okay, before we go on this break, I will have a question. It says, please, barrister, you mentioned renewable. Can I also renew this trademark after I have registered?
Yes. After 7 years, your right over the mark kind of expires. So you have to renew it, for the 14 years, and consequently just keep renewing.
Okay, so if I don't renew the trademark, I may possibly lose it. Or
Exactly, that's the implication.
Oh. Okay, you're still listening to Know Your Rights, our legal program on Lagoon Radio. And we are talking about the value of trademark protection for brands. And you are hearing the voice of Barrister Olufunmilayo Mayowa. We'll go on this short break. When we come back, yes, we'll look at more of them. And also the where the judicial aspect, yes, will come in this trademark. Keep listening to us. We'll be right back.